Welcome, everyone, to the first in what I hope is going to be an ongoing series I'm calling Pints and Politics. On today's episode, Ed Brayton and I will be discussing all things constitutional, its history, various legal approaches to the document, and how it works within the law. Ed has spent years studying the Constitution, especially as it relates to issues concerning church and state separation. He's a past recipient of the Friend of Darwin Award, a civil libertarian blogger, and a former comedian who writes at Dispatches for the Culture War on Pathos. A former editor of the Michigan Messenger, he's also been on Rachel Maddow to discuss the legal case concerning the Hutare militia group, and is probably the only man I know to have insulted Chuck Norris live on C-SPAN. So, Ed, can you tell the audience a bit about your background studying constitutional law?
Yeah, I don't have any formal training in it, but it's something that has always fascinated me. And it started when I was in college. I happened to be taking a course, and I was a political science and political philosophy major. And I happened to be taking a course in the history of the Constitution. And just when Robert Bork was nominated for the Supreme Court by Ronald Reagan. I don't know if you know much of the history, that it was before you were born, but Robert Bork was nominated for the Supreme Court in 1987 by Ronald Reagan, and he was an incredibly controversial figure. He had some just absolutely bizarre views on constitutional law, and he is one of the very few nominees for the Supreme Court that ever got rejected by the Senate. The Senate has to confirm them. It's only happened a handful of times in our entire history. But they voted him down, and so the regular syllabus for the course that I was taking, the professor decided to sort of throw it out and use the Bork confirmation hearings as sort of a launching point to discuss that history, because they were asking him questions about his views on constitutional law, and so he would actually play the video for us, and then say, okay, now let's talk about the history of this particular clause they're talking about, And so it really was kind of a bringing it all to life kind of thing, and I was 20 years old at the time. And that really began my lifelong fascination with constitutional law. And so I have spent all of my adult life now, seriously studying it. And I've reached the point I would never call myself a constitutional law scholar at all. But I have at least gotten competent enough at it that I have twice had constitutional law professors email me and ask me where I teach after discussions about, because they had didn't know who I was and had no reason to know who I was. So that makes me feel like I have a pretty good grasp on the issues, certainly for a layman. So.
All right. I guess my first question about the Constitution is, doesn't it violate the democratic spirit? After all, if most people want to outright ban guns, enforce censorship laws against racists, establish prayer in school, or ban abortion, why should a piece of paper get to be an obstacle?
Yeah, you don't start with easy questions, do you?
Not at all.
This gets to a very core issue in constitutional law, which is this question of legitimacy. I was born in 1967. That's 180 years after the Constitution was ratified. To the year, in fact. I'm sorry, it was written in 1787. Why should I be bound by a document? I didn't sign it. I didn't consent to it. I had nothing to do with it, right? Why should it bind me as a citizen today? That core question of legitimacy is really, really important one. And my answer to that question would be, because it provides a mechanism through which you can adjudicate these disputes. And I assume we're probably going to talk a little more later about the sort of general conservative and liberal interpretation schemes.
Mm-hmm.
I happen to think that's kind of a false divide.
Right.
That you have conservative originalists on the one hand, and you have what they call living constitutionalists on the other hand, on the liberal side. I think that's kind of a false dichotomy.
Because there are exceptions. I know Hugo Black was a liberal, but he was an originalist, and I believe there's one Supreme Court member who's a conservative right now, but he himself holds to the Constitution as a living document.
Well, no, I think that those things, I think no matter how much they protest, everybody views it as both.
Mm-hmm.
They pretend not to, but they do. And there's a concept in constitutional law called legal realism. and I am a legal realist. In the real world, we do use originalism, including liberals. The liberals on the court who reject originalism as a mode of interpretation still do cite the Federalist Papers, cite the debates in the Constitutional Convention, cite current law as passed by the people who signed the document as evidence that their interpretation is correct. They do it all the time. And originalists, those who claim to want to go back to the original meaning, nonetheless accept a whole bunch of things that clearly were not intended originally. A classic example would be the Equal Protection Clause. Now, this is not the Constitution's 14th Amendment, which, of course, is now part of the Constitution. But when that amendment was passed, the men in the Senate and the House that wrote the amendment had to contend with a strong public sentiment against it because they thought that it would overturn laws against interracial marriage. That was the big controversy at the time, that this might be used to void state laws against miscegenation. And framers of that amendment explained over and over again, no, that's not what it's going to do. It has nothing to do with that. It can't be used for that purpose. Now, an originalist would go back to that and say, okay, you can't use that to overturn state miscegenation laws. But in 1967, the year I was born, Loving versus Virginia, the Supreme Court did exactly that. Try to find a conservative today who would say that decision was wrong. You won't find any. Despite the fact that it clearly is an anti-originalist decision. Even originalists allow for exceptions. Even originalists will jettison their mode of interpretation to reach a result that they like while protesting that they never do that, only the other side does. So, my position, my theory on this comes from a man named Jack Balkin, who was a law professor at Yale University. And Balkin is an advocate of what he calls living originalism. And it is a way to form a synthesis between these two ideas. And I think his argument is really strong, both in terms of how you interpret specific parts of the Constitution and on this question that you got to about constitutional legitimacy. Balkin would say this. Balkin would say the Constitution set up a framework. It's what you would call what they call a framework originalism. The Constitution sets up a framework within which we can adjudicate these disputes. Part of that framework is, of course, entirely democratic. You get to vote for people who pass laws, representative democracy. You get to have referendums that are direct democracy and make certain decisions. Part of that is not democratic. Part of that is non-democratic institutions like the federal courts, where once you're on the court for life. You don't have to run for re-election. You don't have to pander to donors to run campaigns. You're there. You can make a decision based on what you think is right, not what is politically expedient. So you have both of these things. There may be some tension between, but the interplay of democratic and non-democratic parts of that framework are important for moving us forward in a deliberate way. So we don't have radical change, but we allow for the possibility of evolving our understanding and evolving our laws to adapt to current moral frameworks. Virtually nobody thought that slavery was wrong at the time of the Constitution. Well, now everybody thinks slavery is wrong, practically. And so that framework allows itself to be amended as well, to be changed through the amendment process. So he would argue that the constitutional legitimacy question is that we should assent to that because it allows us to be a part of that conversation and constantly be working to improve the country.
I see. So
I'll go one level deeper before you jump in.
Oh, go right ahead.
Is that on the other question of then how do you actually interpret the clauses of the Constitution? Balkin would say this. It depends on what kind of language is in that clause, because they use different kinds of language and different types of text in different parts of the Constitution. The obvious example of where there is no room for interpretation, the Constitution says you have to be 35 years old to be president. It doesn't say you have to have reached an age of maturity. It says 35 years old. You can't reinterpret that. It is set in stone. There is no argument that can be made for why we can just arbitrarily decide that that's no longer the case. You can do it at 28. But Look at the First Amendment. Congress shall make no law abridging the freedom of speech or of the press. Now, those are really broad categories. What does that mean? What are the limits on freedom of speech? What are the boundaries of that? Those are very broad phrases. Those are phrases that allow for a great deal of abstraction and allow for a great deal of evolution over time in order to adapt to circumstances that the founding fathers could not have foreseen. This is an example, freedom of the press. Does that include bloggers? I don't know. I mean, it's not something the founding fathers would ever have anticipated. But we can build analogies. One of the primary ways of influencing public opinion at the time of the Constitution was pamphleting. People put up pamphlets all over town, all over the country, arguing for their position. That's not a newspaper. They didn't distribute it, to homes. They just literally tacked it up to trees and passed it around that way. Mm-hmm. That's pretty similar to blogging, isn't it? Certainly, they would have thought that was a protected right, So when we have these more abstract phrases, then we have to appeal to different kinds of evidence to interpret them. Then we're allowed, I think, much more room for abstraction, for application of broad principles to specific areas that couldn't be anticipated. So that's where he would come down on that. Is it depends on the kind of language that it uses, sort of gives you the level of abstraction that you're operating at. So if that makes any sense.
Oh, no, it does. So would you say that the divide between originalists and realists then would be not a matter of like a hard and fast dichotomy, but rather one more of scale? Whereas you have the more originalists who emphasize the original meaning, and then on the other side you have the legalists who don't do it as much, and you really have like a 1 to 10 between them as opposed to category A and category B.
Yeah, I think that's probably a fair way to put it. The conservatives are going to put more of a focus on originalism and another sort of interpretive theory that's similar called textualism. Whereas liberals are going to be more likely to look at sort of the real world consequences. That's where legal realism comes in, where they would say, okay, technically this may, we may have to make an unusual argument here, but the consequences of this are so real for real people that we need to come down on this side. And then there's lots of other considerations too. I mean, this notion that, and this is where conservative originalists, they just make a completely disingenuous argument. This notion, they really pretend like they have this sort of mathematical formula that you just put the problem in the top and you run it through your formula and you get a right answer out at the bottom. And it's all just a matter of application of these inviolable standards. But it's just such a disingenuous thing because they don't actually do that in the real world. They pretend to, they may try to, but everybody ultimately is going to come down most of the time for the outcome they think is the best in a general sense. And not sort of this technical, this is the mathematical answer that comes out the other end of our formula. There was a very famous lecture by Justice Scalia. Every year they hold this lecture in Ohio, the Robert Taft Lecture, and it's always a Supreme Court justice or a really big name, legal scholar that gives it. William Howard Taft was, of course, President of the United States and also a Supreme Court justice, which is the only one in history that ever held both of those positions. Scalia gave the Robert Taft Lecture back in the late 80s, in which he talked about instances in which he would jettison his originalism. And the example he brought up was the Eighth Amendment prohibition on cruel and unusual punishment. And he said, if Congress were to pass a law today allowing for public flogging, public whippings, and putting people to the town square in the stocks like they did at the time of the Constitution, that was absolutely routine. And so he said an appeal to originalism would clearly tell us that was okay. Founding fathers allowed it. They clearly didn't think that was a cruel and unusual punishment. That would be the correct originalist interpretation. He said, but I would regard that as so cruel and so barbaric that I would, at that point, jettison my originalism and say, no, under today's standards, we simply can't allow it. he called himself a faint-hearted originalist in that talk. And so he at least admitted to it, but then at other times he would still just rail about, liberals reaching the result that they thought was right as opposed to what the Constitution required. Well, you just admitted you did the same thing sometimes. So it's just, there's a disingenuousness there that kind of irritates me. But there's also a disingenuous on the liberal side of that sometimes, where they think that rejecting originalism requires rejecting the whole notion that we should look at the practice at the time of the Constitution or the statements of the people who framed it to, as a means of interpretation. And that's wrong too. Yeah, originalism is a perfectly legitimate mode of interpretation. It just isn't A, as easy as conservatives would like us to believe, and B, as dispositive. It's not the final say on the matter. It doesn't just simply decide every case. But lines of evidence from originalism are important and legitimate to when you're trying to interpret a phrase. And liberals who just reject that out of hand, I think, are being sort of equally disingenuous. It can't mean anything you want it to mean. There's got to be something in between. It can only mean this, and it can mean whatever the hell I want. There has to be something in between there where there's a reasonable common ground.
Yeah, that sounds fairly commonsensical to me. All right, so with that out of the way, let's move on to the way that the powers are delegated. Now, I'm well aware that there's kind of a debate between those who favor more federal powers and those who favor more state right government. And I know some people would just say, oh, just consult Article 1, Section 8, and that just explains the scope of the federal government. But it seems to me that the scope of the federal government has grown over time. Would you say that's a fair? Would you say that's fair?
Undeniably true. I mean, and most of that growth really happened because of the 14th Amendment.
Right.
The 14th Amendment, which applied the Bill of Rights to the state level, it did not previously apply, really was a huge boost. And really hardcore libertarians are against the 14th Amendment for that reason. They try to argue that it never should have been passed, that it never was really legitimately passed, and so forth. But the federal government is massive compared to what any of the founding fathers would ever have anticipated. No question.
Even Hamilton?
Oh yeah.
Mm-hmm.
I mean, Hamilton was an advocate of central banking and all that, and certainly was on the strong government side, as opposed to Jefferson and Madison. But within the context of the debates they were having, not within the context of the debates we're having today. We're not even. I mean, we're so far off the scale from what they ever anticipated. But again, that's how that framework evolves, right? That's what that framework originalism allows. Is that our system has evolved in response to a far more complex world, a technological world in which the distinction between the states really no longer matters, right? I mean, at the time, you almost had to have something like the Electoral College because you had 13 colonies and it took days to move between them. And so, those things made much more sense then. Now, what's the difference between Michigan and Illinois? It's a line on a map. I can be there in an hour, from where I'm, hour and a half from where I sit. But, by plane, I can be there in 15 minutes, So, and everybody gets the same news. Everybody gets the same, has access to the same information. So realities have changed and the country has changed as a result of it.
All right. So now I'm just going to move on to a topic that well, since we're speaking about hardcore libertarians, let's go to the topic of nullification. And this power, according to the strongest states' rights advocates, permits the states to refuse to enforce any federal law they see as unconstitutional. Ed, could you make the best case you possibly could for this power as you understand, as they make it? And can you provide a reason why you, I'm going to guess, don't agree with the case?
No, I think it's absolutely nonsense. We settled this 50 years ago. This is the George Wallace argument after desegregation, after the Civil Rights Act, that we're not going to allow black children to attend this school, and we're going to stand in front and block them from doing it. And LBJ said, "Well, here, go talk to the National Guard," and force their way in. It's the same argument Roy Moore has used over his Ten Commandments monument. back in 2003. Justice Roy Moore of the Alabama Supreme Court that says I don't have to listen to the federal courts when they tell me this is unconstitutional because I disagree with them. Well, no. Could I make a case for it? I don't know why I want to. I mean, the argument is just
in the interest. Well, usually in the interest of, it's usually in the interest of building up something as strong as you possibly can in order to more thoroughly knock it down.
Well, I mean, their argument it goes back to this anti-14th Amendment argument, right?
Right.
I mean, just take the Roy Moore situation. The federal court's decision was based on the First Amendment. The First Amendment did not originally apply to the states until 1868 when they passed the 14th Amendment, and then it did. That was the entire purpose of the 14th Amendment, was to give the federal courts, the federal government, the power to prevent the states from violating the rights of its citizens. And explicitly, the first 8 amendments of the Bill of Rights apply to the states after that. Their argument for why that's illegitimate is many of them, and I don't know that Roy Moore makes this argument specifically, but there are certainly some of the really hardcore libertarian types that do, that the 14th Amendment was illegitimate because the southern states didn't get to vote on it. It was a condition of their readmission into the Union after the Civil War. Congress passed this, but they passed it at that point. Everyone from the South had been expelled. They had seceded. They had left the Union. So when the North won the war and said, and they said, okay, we want to rejoin. They said, okay, here's some conditions. Number one, the 13th Amendment, which banned slavery. You have to agree to ban slavery. You have to agree to the 14th Amendment. Well, you don't have to agree with it, but we're going to pass it, and it's going to apply to you anyway. And they did. And the 15th Amendment. So those 3 post-war amendments were part of the condition of their readmission. That's their argument, is that because the South never actually got to vote on those things, it doesn't apply to them. Well, no, that's just wrong. If you want to be part of the Union, that was the condition for joining. You lost the war. Too bad, so sad. And the fact is, regardless of whether someone thinks that that was right or not, it was 160 years ago. We're not going back. Mm-hmm. The Supreme Court is not going to tomorrow go, oh, you know what, that 14th Amendment thing, that was never right. Every decision we've ever based on the 14th Amendment is gone now. No.
Never even happened.
Join us in the real world. We're 150 years past this argument. The argument was lost. Get over it. Join us,
Also, when it comes to the states' rights in the South, from what I noticed, they've never even been consistent on it. For example, the fugitive slave law, that was something that abridged the North's right to say, yeah, these slaves are on our land now and they have their freedom. You can't recapture them. Yet at the same time, the court sided with the South, who appealed to their own right to go after.
And that's not just a North-South thing. When it comes to this question of federalism, everybody's a hypocrite. Mm-hmm. Absolutely everybody on all sides. We are all in favor of states' rights when that reaches the result that we want. And we're all against states' rights when it doesn't. Mm-hmm. We're all for states' rights, some of us, when it comes to legalization of marijuana, right? The federal government should leave the states alone, man. Let the states do what they want.
Right.
But then there's any number of other issues where we want the federal government in there telling, regulating police power, for example, coming down on police departments. Well, the police power was originally solely a state authority under the Constitution. But the police power can be enforced and used in a way that violates provisions of the Bill of Rights, certainly the 14th Amendment, the Equal Protection Clause, the Due Process Clause. Those are important when it comes to criminal procedure. So everybody is in favor of states' rights when that gets them what they want. And then they throw it out when they don't. So, they take this current thing over sanctuary cities is a great example. Right? And Donald Trump's all for states' rights when it comes to, let's say, putting work requirements on welfare. States ought to have the right to do that. The federal government shouldn't stop them from doing that. But when it comes to sanctuary cities, when it comes to enforcing immigration law, no, they have to do what we say. So everybody's a hypocrite on that question.
Where would you say do you have a kind of rule of thumb that you like to use when trying to see whether or not this applies to the state. Not necessarily a hard and fast rule, but just like a rule you usually use just to see on the face of things.
Not really. It really does come down to what power is being exercised and on what basis is the federal government intervening.
Mm-hmm.
Sometimes it's legitimate, sometimes it's not. I mean, the sanctuary cities thing is a good example of that because, and there's a lot of confusion over this because Trump lies about it a lot. But basically, what the whole sanctuary cities and now California as a sanctuary state, basically what that means is the local police will not help enforce immigration law itself. Now, if they arrest somebody who is an undocumented immigrant who has also committed a real crime, not just been here in violation of the immigration, but has committed an actual crime, theft or burglary or assault or murder or whatever, they're not going to let go. They're going to prosecute them at the state level for those crimes because those are state level crimes. But immigration law is solely a federal law. There are no state laws on immigration. The Constitution forbids the states from having laws on immigration. It puts that power solely with the federal government. Federal courts have ruled multiple times that local law enforcement is not responsible for enforcing laws that are strictly federal. They don't have to do that. And some of them have chosen not to do that. And so in that case, we have, I think, a legitimate argument to be made for states' rights based on the structure and text of the Constitution and based on the separation of powers. In other cases, it's not so clear, I think. You sort of have to take them one at a time. These things tend to, one of the things about constitutional law is that the media and people who aren't really versed in the details of it focus solely on the outcome of the ruling. And usually those rulings, even ones that have this sort of really big effect, will turn on some little technicality. They'll turn on some little turn of phrase in a law or in the Constitution or on some precedent that nobody's ever heard of. Usually the rulings tend to be very technical in nature in terms of their reasoning, even if the result is what everybody looks at, And so there really is a necessity when you're arguing these cases for the Supreme Court to look beyond the outcome and say, what's the basis for the decision? What is the actual textual legal basis for it? And is that legitimate? If that's legitimate, then the outcome almost doesn't matter, So constitutional law is very complex and ever evolving. So there's a lot more to it than just, I don't like the way that turned out,
Has there ever been a ruling that you disagreed with the outcome, but you fairly well understood the result and came and acquiesced to it? I know,
Sure.
Before you answer, I know Justice Scalia himself is not a fan of flag burning, but he actually came down on the side of, there should be no ban on flag burning.
Right. Yeah. In 1986, he was part of that ruling in Texas v. Johnson, and that's what he said. He said, I think burning a flag is horrible. I don't think anybody should ever burn a flag. But the First Amendment pretty clearly protects that as a expression of political protest. And so, kudos to Scalia for seeing beyond his preferences. When I said that everybody violates their declared mode of interpretation when they don't like the outcome, they don't do it all the time. We're human beings. None of us are entirely consistent, And there's an example of where Scalia is absolutely right. I've had cases like that where I'll give you an example just from last term, the Trinity school case out of Missouri. The federal funding or state funding for a religious school to put rubberized material around the playgrounds. State of Missouri has this program where they would give grants to schools to put rubberized material on the playgrounds to prevent kids from being hurt.
Right.
And they were sued over that by a religious school, Trinity Lutheran School, because they applied for it and were turned down because there was an amendment to the state constitution called a Blaine Amendment, which forbid any state taxpayer money from going to going to any religious church or school. And while I generally agree with that principle, that I don't think that that taxpayer money should go to fund religious activities, I think the court had a pretty solid basis for saying look, if this is a secular-minded program. This was not the intent of this program, and the effect of this program is not to advance religion. It's to protect kids when they're on the playground. They're going to be injured less often if they're falling into, cut up old tires than if they're falling onto concrete or, wood. And so we have here a generally applicable law that applied to all schools, or should, that does not advance the teaching of religion in any way, and that had a clear secular purpose of protecting children while they're at school. They don't need any less protection if they're in a religious school than if they're in a public school. So I think while I sort of agree in principle with the notion that we shouldn't be giving taxpayer money to religious entities, here's an example of where, okay, guys, this really isn't a big deal. Let them, let's protect some kids, and I think the basis for that ruling was correct.
Wow. Well, now that we've gone on the topic of church-state separation, I actually want to move on to certain amendments within the Bill of Rights. And of course, we're going to start off with the first one. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people to peaceably assemble and to petition the government for a redress of grievances. Now, we touched on this before, but it bears repeating. The amendment says Congress shall, and yet why does this amendment apply to the state and local government? And since when has that happened, since you said that it's expanded since then?
Right. That was, again, the 14th Amendment, which applied the Bill of Rights to the state. So it's no longer just Congress. It's now all government entities at all levels that it applies to. So it took a while for that to start to be applied by the courts, because, of course, the courts can only take the cases that are in front of them. And so, as an example, on the Establishment Clause, the Congress will pass no law respecting the establishment of religion. The first time that was applied to the states was in a 1947 case. So it took from 1868, the passage of the 14th Amendment, until 1947 before they first applied it to the states. And that was in a case out of New Jersey involving the question of whether, and again, this goes back to taxpayer funding, whether they could, parents could claim a tax break for whether parents could use buses to send their kids to private religious schools as well as public schools. And Hugo Black, you mentioned him earlier, wrote that decision. And this was the first time the Supreme Court had cited the metaphor of the wall of separation between church and state as a basic principle. Now, what's unusual about that case is, even though they said, number one, that the Establishment Clause does apply to the states, and two, that the Establishment Clause requires a wall of separation between church and state, despite those two things, they still ruled in favor of the parents in that case. So it was a rather unusual case, but it did, by putting those two basic principles in there, then lead later on to all sorts of decisions. And then after that, starting in 1961, 62, 63, you started to have rulings involving things like mandatory prayer and mandatory Bible reading in public schools. You had Engel versus Vitale in 1962, and a couple of other cases that said public schools can't force children to read the Bible. They can't force them to say prayers. They can't. In one of the three cases, they can't force them to recite the Lord's Prayer. There were two prayer cases. One involved the Lord's Prayer, which schools in Pennsylvania required every year. That was a case called Abington Township versus Shemp. That was also a Bible reading case. And Ellery Shemp, who was the plaintiff of that case, is still alive and is a friend of mine. Wonderful guy. And then the other one involved an actual government-composed prayer that children had to stand up every morning and recite this prayer that the government composed for them and made them write. And it has always baffled me that the Christian right in this country points to those decisions as that was the beginning of the end. We kicked God out of schools and everything went to hell. And I always think about what you're asking for. The same people who scream about freedom of religion are against a ruling that said the government cannot force non-Christian children to recite government-composed Christian prayers. If that's not a violation of religious freedom, what in the hell possibly could be? I mean, their position is so contradictory, which is why I've always said when the Christian right says religious freedom, what they really mean is Christian privilege. They really mean the right to impose their religion on other people, almost all the time.
They might have been happier in the Commonwealth because we actually said the Lord's Prayer in school up until 1989, I believe, in my own country. So,
I didn't have any of that when I went to school in the 70s and 80s, but that, and there's still controversies about that today. There are still, now it's some of it deals with the Pledge of Allegiance, which the court actually ruled on way back in 1947. You can't force children to recite the Pledge of Allegiance, whether it includes the phrase "under God" or not. At the time they made that ruling, "under God" was not part of the Pledge of Allegiance. They just said you can't compel speech. You can't compel people against their conscience to pledge allegiance to something.
I believe, though, there's still some debate about whether or not putting "on God we trust" on currency or the like as well. Yeah. But isn't that kind of considered to be not necessarily religion, but more along the line of some ceremonial deism, I believe?
Yeah, that's the phrase the Supreme Court has used, is ceremonial deism, to justify. Basically, they just carve out an exception. Mm-hmm. I mean, if you're going to follow the logic of the First Amendment and the logic of the Establishment Clause, no, clearly it's unconstitutional to put that on the money. Mm-hmm. But the Supreme Court long ago ruled that this was sort of an incidental case of, nobody's rights are really being violated here. It's kind of what the people want. It's kind of traditional. So we'll let it go. Basically, they've just carved out an exception there without any real logic to it at all. But at this point, I think there were a series of cases filed by a guy named Michael Newdow a few years ago on this, and they were very quickly dismissed. And then he kept appealing, and they kept getting dismissed. And I said at the time, you're just wasting your time. Mm-hmm. There are other places where we need to be working on church-state issues where we have a far greater likelihood of success. You're not going to win this argument anytime soon. So let's focus on where we could maybe build that wall a little stronger in other places where we have plausible pathways to victory, because we aren't winning that one.
Right. To be fair, though, at least in my opinion, does the notion of a god of nature necessarily violate this kind of amendment? Because one could technically hold a belief in an inactive god and not technically hold to any religious kind of doctrine.
Sure, but then you still have the fact that there's a sizable percent of the population doesn't believe in that god either. Why should the government be taking any position on this whatsoever? The other thing I would note is that so the Supreme Court evaluates Establishment Clause violation on the basis of something called the Lemon Test.
Right.
Well, sometimes they use the Lemon Test, and sometimes they don't. It depends on what result they want to reach. So, but the Lemon Test is sort of the primary one. And the Lemon Test is a three-prong test. First prong is a law has to have a clear secular purpose. The second is that it has to have a clear secular effect. And the third is that it has to avoid an excessive entanglement between government and religion. The purpose, intent, and entanglement prong. Now, the purpose prong is often the most important one. And when you look at when they put "in God we trust" on the money and when they added "under God" to the Constitution, that was in the early 50s during the Red Scare and the McCarthy years. And when Congress passed those laws, you can know what their purpose is because we have the congressional record. And their purpose was very clearly to inculcate religious belief, specifically Christian belief, in order to distinguish us from the godless communists of the Soviet Union. So under the purpose prong of the Lemon Test, there is no question whatsoever that this is a violation of the Establishment Clause. Now, like I said, Supreme Court applies the Lemon Test except when they don't. And that led to, that fact led to my favorite written opinion in a Supreme Court ruling ever. Because they also sometimes they use something called the endorsement test, which came from Justice O'Connor. Sometimes they use something called the coercion test, And it just all depends on what result they want to reach, what kind of consensus they can build. And in a case called Lamb's Chapel, Justice Scalia, who, despite the fact that I disagreed with him on virtually everything, was A, absolutely brilliant, and B, a really good writer, and C, incredibly funny, wrote a concurring opinion in this case in which he took his fellow Supreme Court justices to task for being inconsistent. And he compared the lemon test to a late-night movie ghoul that we could summon from the grave to scare the little children. And its power lies in the fact that we can then order it back into the tomb when we don't like what it does. It's just a brilliant piece of rhetoric. And he was right. He was absolutely right. The Supreme Court has been wildly inconsistent when it comes to church and state matters. My dear friend Dan Ray, who is a retired professor of constitutional law and the co-host of my new podcast, has a great line about this, where he said when he would get to the First Amendment and the Establishment Clause in his common law classes, he would just stop and sort of issue this disclaimer: don't try to make any sense out of this, just memorize it, because there is no coherency to it. And he gave me this analogy. He said this is a mess of the Supreme Court's own making, because they have tried to fit the square peg or the round peg of religion into the public square. And so by trying to force it in there, they've had to make all of these, they had to jury rig things over and over again. And okay, we're going to do this here, but then we don't like that in this particular case, so we're going to find a little end around. The classic example of this is 2005. On the very same day in 2005, the Supreme Court issued two rulings involving the exact same issue: a Ten Commandments monument on public property. One was at the state capitol in Austin, Texas. One was at a courthouse in McCreary County, Kentucky. They issued two rulings on the same day involving the same issue, and they were opposite rulings. In the Texas case, they said that one's fine, that one can stay. And in the Kentucky case, they said that one you got to take down. That's how confused their jurisprudence is on this issue. It makes no sense whatsoever.
All right. So another question is the exact phrase "separation of church and state" does not appear within the First Amendment itself, and I know you're going to also point out other words in the Constitution not included are balance of powers, et cetera, et cetera.
Checks and balances, separation of powers.
Right. Now, how these extra constitutional phrases, how did they come to pass and be brought in? Because separation of church and state was something Jefferson himself said as a commentary upon this amendment.
Right. And Madison. Madison used that phrase in various variations on that phrase quite a lot. He preferred separation of religion and government, but he also used the phrase separation of church and state. Those are phrases that the founders themselves used to describe the principles on which those provisions were based. And so, the distinction between Article 1 and Article 2 and Article 3, that's separation of powers. They use that phrase when writing things like the Federalist Papers and explaining what the Constitution did, that this structure was designed to separate the powers so that no single branch of government is all powerful, because that protects everyone's rights. So that's why we use that phrase, checks and balances, same way. And so that's how that, separation of church and state came to be, was that it's something that Thomas Jefferson, in a letter to the Danbury Baptists, had first used that phrase in 1801 to describe the purpose and effect of the First Amendment. Now, Jefferson wasn't actually there when the First Amendment was passed. He was in France. He was our ambassador to France at the time. He wasn't involved in either writing the Constitution or framing the Bill of Rights. He was in France that entire time. Now, he, of course, is still very influential. His ideas were extremely influential, principally through his influence on James Madison, who was his protege. James Madison is frequently called the father of the Constitution. He was the sort of strongest voice and primary person in both the Constitutional Convention in 1787 and the framing of the Bill of Rights in 1790 and 1791 in Congress. When it came to the Bill of Rights, we got the Bill of Rights because some of the states wouldn't ratify the original Constitution without it. And so a promise was made. If you ratify it, we will add a Bill of Rights to the document immediately. Okay, we agree. So that got it ratified. Congress then set about framing that, and James Madison was a member of the Senate. And James Madison brought the first version of the Bill of Rights to the floor. So, okay, we have to fulfill our promise. We have to put together a Bill of Rights. I have a list of 12 amendments that I'd like to propose. We will use those as the basis for debate on what should and shouldn't be in there. And that's what sort of launched the whole thing. So he's known as the father of the Constitution. And he was a strong proponent of separation of church and state, stronger than Jefferson even in many ways, and stronger than even the ACLU is today on many issues, particularly after he left office. He became very concerned because he saw that some of the little tiny things that didn't seem to matter much, that he thought were violations of the First Amendment, were being used to justify bigger things. And particularly two things, congressional chaplains and military chaplains. Now, when he was in Congress, he initially voted for a bill to establish and pay for a chaplain for both houses of Congress in 1790. He was part of that committee, and he voted for it. But then he saw that that was used rhetorically to justify other things. Well, if we can do that, why can't we do this? And so he wrote a document called the Detached Memoranda after he left office, in which he argued that these little encroachments have to be treated as big ones because they justify bigger ones. And so we have to guard very closely against even these, what seem like very, very minor encroachments on the separation of church and state. Congress should not have chaplains. The military should not have taxpayer-paid chaplains. If the churches want to pay to send someone with our troops to act as a chaplain, that's fine. He also argued that churches should not be given permanent charters, and that they should be restricted on how much land they can own. So he was more radical. The ACLU actually takes the exact opposite position. They defended Jerry Falwell in a case where he was challenging state law in Virginia that did put a limit on how much property a church could own. And the ACLU intervened on his behalf in that case. So Madison was really very radical on these, sort of the most radical of all time, a bit of an outlier on that. But
right, and when it comes to church-state law, isn't there also a notion that if there is some kind of funding going on, or if there is some kind of use of, let's say, government property, then it has to apply to all religions equally. You can't discriminate against anyone that's trying to.
Yeah, and to religion and non-religion equally. And that case with the late night movie ghoul was a case called Lamb's Chapel. It was an important case on that very issue. And it was a 9-0 decision, and as it should have been. But it was a case that involved a church called Lamb's Chapel in New York that wanted to rent a school auditorium to show an anti-abortion film. And the school district had a policy against renting their facilities to religious groups. They challenged that in court and said, look, you have a public forum here. You allow community groups to rent your facilities, but you won't let religious community groups do it. That's discrimination. We have an equal right to rent those facilities as any non-religious group. And it went all the way to the Supreme Court. The Supreme Court ruled 9-0, as they should have, that no, you can't discriminate in that way. If you're going to open up your facilities for rent or use by the community, then it has to be on an absolutely equal basis. You can't discriminate on the basis of religion or content or viewpoint. They have allowed restrictions on things like nudity and stuff like that, profanity, and then the basic restrictions against like inciting a riot and stuff. But as a general rule, yeah, the Supreme Court has said, and then correctly so, that you can't discriminate against religious groups in this regard. That's ridiculous.
Mm-hmm. Now, so still on topic of the First Amendment, maybe to move on a little from church-state separation, how about covering hate speech, which, this is kind of a topic that's come up recently, especially with the rise of the alt-right.
Yep.
The term hate speech, does it have any kind of legal precedence?
None whatsoever, not in this country. In Canada, it does.
Sadly.
Where you are. But yeah, in the United States, there is no category called hate speech in the law. And so people say, well, you can ban that. It's hate speech. No, you can't. I'm sorry. And on this question, I am an old-fashioned ACLU liberal. I think that it is very important to protect the free speech rights of everyone, not just those that we agree with. My hero is a man named David Goldberger. I don't have many heroes, but David Goldberger is one of them. David Goldberger was an attorney who, in 1977, was the ACLU attorney defending the American Nazi Party in the case that went all the way to the Supreme Court when they wanted to march through Skokie, Illinois, which is a town filled with Holocaust survivors. One of the most controversial Supreme Court cases in history of the country. And for obvious reason. I mean, this is horrifying. Nazis marching through a town of Holocaust survivors?
We don't have any of that today.
Yeah, well, now we do again, but that's horrifying. I mean, who's in favor of that other than Nazis, right? It's a horrible, horrible thing. But the ACLU took the case, and they lost half their membership as a result of it. And they won the case. And David Goldberger, whose grandparents had died in the Holocaust, was the attorney who took that case. And he held his nose, to say the least, to defend Nazis, because he said, if we don't defend it for those that we despise, we don't deserve defense for our views either. We can't allow the government to make those kinds of decisions on who can and can't express their viewpoints, no matter how vile those viewpoints may be, because it could just as easily be turned against us. So in protecting them, we are protecting ourselves, and we are protecting this basic principle. David Goldberger is now a law professor at Ohio State University. He remains to this day one of my heroes. I think that takes tremendous courage. I think it takes tremendous principle. And I get irritated when people say, when some of the really sort of hardcore leftists on this argue that if you're defending their right to say something, it's because you agree with them. No. Now, there may be some cases where that's true, of course. There's an attorney here in Michigan who is a white supremacist who takes those kind of cases. But it sure as hell isn't true for me. I mean, I am an anti-racist activist. I fight against racism every day as much as I can as a white ally, and that's limited. But as hard as I can, I hate that. But I still think we need to protect them. And I think particularly I hear this on the part of atheists, my fellow atheists, and I go, boy, as an atheist, do you really want the government to have that power to decide who gets to say that in a country where we have one atheist member of Congress out of 535? You really want those decisions being made? When you say, and this is what I tell people all the time, when you say that person X or group X should not be allowed to express their viewpoint publicly, they don't have a free speech right to do that. What you are really saying is, I want Donald Trump to decide whether they have the right to say what they want to say or not. Because it's the government that enforces that authority. And you cannot write it in such a way to prevent its application to you just as easily as it applies to somebody else. They will find some pretext to apply it to you if they want to shut you down. And we can't give them that power.
Especially in a country where religious sensibilities are easily offendable.
Absolutely.
I mean, yeah. Now, although when it comes to the limits of freedom of speech, I think that it's drawn out in terms of at least a threat when it comes to how immediate it can be. Because it's one thing to say, yeah, the government. It would be one thing for me to start up a blog that says the American government should be overthrown, we should reinstitute monarchy, and we should do it violently. But it's another thing in general to actually say, hey, we're marching down there to town hall to overthrow them and inside our own local fraction.
Right. There are exceptions to the First Amendment. No right is completely unlimited. Hate speech is not one of them, but incitement to violence and incitement to riot are. But in the United States, the courts have drawn those very, very narrowly. And as you said, it's the sort of immediate proximity, the immediate threat that matters. There has to be a clear nexus between the speech and the violent effect. So it's not enough. A guy could stand in front of a crowd and say, I think all Muslims should be shot. that's still protected under free speech. But if he said, "Did you bring a gun? Let's get our guns. Let's march down to that halal butcher down the street and kill that son of a bitch."
Right.
Now you've got a direct threat. Now you've got a specific nexus between the speech and the violence. And that the courts would say, no, you can't say that. You're actually threatening some specific person's life now. I don't know where exactly that line should be drawn. I mean, we could probably come up with different ways of phrasing things that kind of skirt the line, you know. As a general rule, obviously, we don't want anybody committing violence in circumstances like that. And I might be a little more amenable to a little wider degree of latitude for the government to shut something like that down. That's actually calling for violence, you know, not for breaking the law necessarily, not for saying, you know, we should defy the marijuana laws or we should defy, you know, a law and you know, smuggle refugees into the country. You know, there are cases where saying, you know, telling a crowd we should violate the law is perfectly legitimate. But if you're actually threatening violence against someone, then, you know, maybe there's a little more room there for that. But in general, I think our courts have done a pretty good job of drawing the exceptions to free speech in a very narrow way so that they don't catch up too much, but still provide some protection.
Right.
You know, for individual people. I think we've done a pretty good balance there.
And doesn't that also extend to private property as well as the personal well-being of someone?
Yeah, generally, you know, the protection of property is there too. But there's some sort of odd cases there. There's a case called St. Paul, RAV versus St. Paul out of Minnesota, where so white supremacists actually burned a cross on the property of a black family. And the Supreme Court said you can punish that as trespassing. You could punish that as a violation of the fire code. You can't punish it as a matter of making a threat. It wasn't a direct threat. Now, I'm not sure I agree with that. The history of burning crosses in this country pretty clearly shows that when you burn a cross, you're threatening somebody. When you do it on the property of a black family, that's a pretty obvious threat to me. So I don't think I agree with that ruling. So, you know, there's an old saying in legal terms, difficult cases make bad law, but difficult cases make most law. You know, that's the thing. Because if they weren't difficult, then, you know, they'd be clear and easy and they never would have gotten that far, you know. Some of these things come down to these really technical, narrow distinctions between things and judgment calls on the part of judges and justices. And, you know, sometimes they get it right, sometimes they get it wrong, and that's just inevitable, I think. But like I said, as a general rule, I think our courts have done a pretty good job of protecting freedom of speech to a maximum degree while also protecting the rights of people who might be targeted as a result of that speech.
And I believe on the cross thing, if I remember correctly, even Clarence Thomas would have sided with you on that one. He's the most conservative judge on the court.
I don't know. This was before he was on the court, so I'm not sure he'd ever addressed that. So,
yeah. Then I'm probably thinking of another case. I remember him addressing the cross burning, but I'll just leave that aside for now.
Yeah.
Okay.
By the way, I have really strong and unusual views on Clarence Thomas, too.
Well, yeah, I believe we've both discussed that, where a lot of liberals are quick to say that he was just a lapdog of Scalia, whereas no, he's actually very conservative within his own right and has even moved Scalia to the right as well.
Yeah, he had more of an influence on Scalia than Scalia ever had on him. And that's something that it's just become such a cliche. People have heard it repeated, they just assume it's true. But anybody who really watches the court and reads the rulings knows that I'm right about that, that it was Thomas that moved Scalia. In his very first week on the court, there was a case in which the initial vote was 8-1 with Scalia, with Thomas in dissent. In the first week he was on after he got confirmed. And when they circulated the opinions, Justice Scalia read the minority opinion by Thomas and said, you know what, he's right. And 8-1 became a 7-2. That happened the very first week he was on the court, and it happened more than once. It happened multiple times during his time in the court. So Thomas drags Scalia to the right. And the other thing is that I hate that criticism that he doesn't ask questions. You hear this from people, you never ask questions, you're just sleeping up there. You know what? Thomas is right. Stop interrupting the lawyers and let them make their case. Because most of the questions that are asked aren't really questions, they're arguments. The Supreme Court justices, when they do ask questions, they're really arguing with one another. You know, that's why you see, if you read the oral arguments or you're listening to the audio of them, you'll see a lot of the times you'll see questions phrased like this. Isn't it really your position that A, B, and C? You know, isn't this what you're really trying to? They're goading the attorneys to make a stronger argument for them. You know, so they're arguing with one another through a series of questions, you know, aimed at the attorneys. Thomas has addressed this, and I think he's absolutely right. He said, look, by the time we hear oral argument, we've had rulings at the district level, we've had rulings at the appeals court level, we have the entire trial record, all the expert testimony, all of the briefs from those two levels. We have sometimes dozens of briefs filed by various groups on our side, plus the briefs filed by the plaintiff and defendants in these cases. We have read all of that. We have synthesized all of that. We already know how we're going to vote 99% of the time. They get 30 minutes to make their case. That's all the oral argument is. Each attorney gets 30 minutes. Let them talk. Let them make their case and stop interrupting them. He's right. Let them make their case. Stop grandstanding. And so on that issue, I think he's absolutely right. That it's the other justices that ought to shut up. I mean, every once in a while, there will be an important question. There will be some times where you just go, where a Supreme Court is going to say, wait a minute, aren't you contradicting yourself there? Or, you know, well, what about this hypothetical circumstance? There are going to be a few questions here and there that are perfectly reasonable and are not being used as a pretext. But 90% of the time, they're just arguing with one another. And they already know how they're going to vote. They could get rid of oral argument and it would change almost nothing.
So, all right. Well, I think we've exhausted the First Amendment. To move on to the Second Amendment, I'm not going to go through all of them. I've chosen the four I think are the most interesting.
Nobody ever talks about the Third Amendment.
Yeah, I mean, quartering soldiers, though. I don't think
nobody ever talks about that. It was so important at the time, and yet nobody ever even mentions it. Second Amendment.
Second Amendment, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. To start off with the most basic question, does this amendment only really apply to muskets and everything they had at the day?
No, of course not.
Yeah.
That's kind of a silly argument. I mean, that's like saying freedom of speech only applied to poured ink printing presses and not to computers. Technology changes, okay? This is another issue where I partly part ways with my fellow liberals, in that I do think that the Second Amendment confers an individual right to bear arms. But I don't think that right is unlimited. I think the Supreme Court actually got this pretty close to right in the Heller decision involving the gun ban in Washington, D.C., the first time that they actually had said several years ago that the Second Amendment confers an individual right to bear arms. They had never actually addressed that question before, believe it or not. And Scalia wrote the decision in that case, but basically what he said was, yes, you have an individual right to bear arms, but no, that doesn't mean there aren't limits on there.
So I can't have an Apache attack helicopter?
Well, that's ordnance. That's not arms. That's one of the distinctions that needs to be made.
Rocket launcher, then.
Right, grenade launcher. No, you can't. It doesn't mean you have the right to own those. Those are reasonable restrictions. But the other thing is that, and there have been 2 or 3 cases since then, one involving Chicago, where the court has upheld gun control laws because they said, yeah, okay, so there's an individual right to bear arms, but that's a perfectly reasonable restriction. And so I think there's a balance to be struck there. And I think the Supreme Court has so far at least done a relatively good job of doing that and saying, like, we're not going to let you just ban guns, which is what D.C. tried to do. But we're going to allow background checks. We're going to allow restrictions on, if somebody has a record of criminal violence, domestic violence, then of course you can say they can't own a gun. If someone has a record of psychological problems that might tend to make them more violent, and most psychological problems do not, of course, make anybody more violent. But there are cases where that may be, then of course you can restrict someone's right in that case. So I think there's a balance to be struck there between saying, yes, you have a right to own guns, but we can ban automatic weapons. We can ban machine guns. We can, put in really strong background checks. The basic sort of, I hate the term common sense. I really do. But what is generally considered to be called common sense gun control laws, the Supreme Court is going to uphold those, I think, regardless of that Heller ruling. So I think we're doing okay there. Clearly, we have a problem with guns in this country. I mean, we do have a problem with guns, no question about it. But I think those can be addressed with reasonable restrictions on gun ownership, stronger background checks, and all of that, without actually doing away with the individual right to own guns for other purposes.
Right. Now, when it comes, although there are some policies that do, without outright banning the weapon, become kind of a de facto ban. Like if someone was to, if the legislator tomorrow was to pass a 1,000% tax on pistols, I'm pretty sure that would qualify as being an infringement on the amendment, wouldn't it?
That's an interesting question. I don't know. It's certainly, I mean, Congress has the power to tax.
Mm-hmm.
And the courts aren't going to second guess the power to tax. Whether they would accept an argument that it was sort of a de facto ban, it's a really interesting hypothetical I've never heard before. I don't know the answer to that. I on the face of it, I would say probably not, but I wouldn't bet on it necessarily. It's like Chris Rock's idea that you should be able to own guns and every bullet should cost $5,000, right?
Right. Then that person who would have died would have definitely deserved it.
When I sell my car, I'm coming back to kill you.
All right. So now, usually another defense brought forward, and this was pretty common up until Heller versus DC, was it only applied to the militia or groups of people, not necessarily individuals, wasn't it?
Yeah, it's an argument made that that first clause, a well-regulated militia, blah, 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 so it applied only to militias, not to individuals. But there really wasn't much of a distinction between those things at the time. Every able-bodied male was considered part of the militia at the time. Mm-hmm. And in fact, there were laws that required every single household to own a musket and a certain amount of ammunition because at any given time they could be called up. Remember, we didn't have a standing army at the time. Mm-hmm. So the militia was our army. Every able-bodied male was considered to be part of that militia. And every able-bodied male was expected and sometimes legally required, depending on the state, to own a gun. So that distinction between militia and individuals wasn't nearly as clear in the 18th century as it is now. Now that we have a National Guard, that we have, a professional standing all-volunteer army and so forth. So now the well-regulated part of that may be more important than the militia part. It may be that everybody was required to be part of the militia, but that militia was regulated by the government. Well, militias today aren't. I mean, you can count the National Guard as a militia, I suppose. But now we have all of these private militia groups running around in the woods pretending to be soldiers. And they certainly aren't well regulated. And they like to do violent things like blow up the Oklahoma City government building. So in Michigan, where I am, tends to be a hotbed. I mean, the Michigan militia is where Timothy, what's his name? The guy that blew up Timothy McVeigh. He was from Bay City, Michigan. He was part of the Michigan militia. And the Hutari militia that I talked about on the Rachel Maddow show many years ago was based here in Michigan. There's a ton of militia. There's like 8 or 9 different militias in various parts of the state. We also, unfortunately, have long been a hotbed for white supremacism, and those two things are not a coincidence. Militias and white supremacism tend to go hand in hand. So, there clearly is a danger here. And I don't know that the Second Amendment is the way to go about that. I think keeping a close eye on them and infiltrating them and sending in informants is the way to keep track of them and keep them from doing bad things. Now that, of course, gets us to the Fourth Amendment, which is probably one of the other ones you wanted to talk about.
Actually, I did not have the right, which was actually the next amendment I want to talk about was the right of the people to secure in their person, houses, papers, and effects against unreasonable searches and seizures shall not be violated. Yeah, that one.
Yeah, that's the Fourth Amendment.
Okay, I didn't number these. I forgot to number them, so forgive me.
Fourth Amendment, very, very important, and I'm a huge fan of it. Unfortunately, the courts have weakened it so much that I'm not sure it applies all that much anymore.
Thanks a lot, Patriot Act.
Yeah, and other things. Yeah.
So aren't there kind of reasonable objections to that, though? Like, let's say the police know that illegal activity is going on, someone's in immediate danger, and they really don't have the day to go and get a warrant. And there is
an exception for that.
Right.
There is an exception for that. That if you have to move quickly to protect life, then Fourth Amendment doesn't apply. And under that circumstance, then the standard is lowered from probable cause to reasonable suspicion. Mm-hmm. And that's the sort of lower standard that is applied in certain circumstances, wrongly in many cases. Now, when it comes to protecting life, then of course we're all going to agree that you shouldn't have to go get a warrant to bust into a building if somebody's life is in danger. But they apply the reasonable suspicion standard the Supreme Court has, and the police do all the time, to routine traffic stops. Search the car. Well, I had a reasonable suspicion there might be drugs there. Well, that's a much lower standard than probable cause. I caught a whiff of marijuana. Therefore, I'm going to tear this whole car apart looking for marijuana, and there's nothing they can do about it. Or the use of drug dogs, which ought to be illegal because they're wildly inaccurate. But under Supreme Court precedent, if they bring a drug dog to your car and the dog alerts, as they call it, which could be anything, then that's it. You don't need a warrant. You can search that car. You can search their person. You can even go back to their house, search their house on that basis. But we know from study after study after study that drug dogs are wildly inaccurate, and they are usually responding to nonverbal cues from the police officers that handle them. They're looking for approval, and the police officer wants them to alert. And there's all sorts of ways that you could just, and the officer doesn't even have to do it intentionally. Mm-hmm. This is just human nature. You're looking for a certain result. The dog can sense that. They know what's going to get them their treat. The use of dogs should absolutely be illegal, but the Supreme Court has upheld them time and time again against all science and reason.
And now, I actually have to ask a question, not just with regards to the Patriot Act, but also with the other amendments. Do these apply to everybody that's under trial in the United States, or does it only apply to American citizens and green card holders?
No, there is no restriction to American citizens. That you get due process, whether you are here illegally or legally, you should get due process. Mm-hmm. The Fourth Amendment says persons, not citizens. Mm-hmm. So, and most of the Bill of Rights is that way. There's actually very rarely is there a situation where the law applies differently to a foreigner than it does to an American citizen or a green card holder, and that's the way it should be. If these are basic principles of justice, they should apply to everybody, and they are.
I've often heard as a precedence for prejudice when it comes to people coming over here or coming into the country. A citation of the American government discriminating against certain groups, like in Eastern Europe, anarchist groups, for example. And they say, well, okay, if we could apply it to political ideologies, why not religious ideologies like Islam?
Well, under American law, that's just not allowed.
Right.
So, but other countries may do things differently. But Well, under American law, you can't say we're not going to let anybody in this as part of this religion to come to the country. I mean, look, yes, there's a significant threat out there from Muslim terrorists.
Mm-hmm.
I mean, come around, like you come from Lebanon, you know this better than than I do. This is a real threat, but the percentage of Muslims who support terrorism is vanishingly small compared to there's 1.5 billion Muslims in the world. If they were all terrorists, we would all be dead. Okay, if more than even a small percentage of them were terrorists, we would all be dead. They got the numbers, man. And so, the response to the threat of terrorism is good law enforcement action. It's good intelligence action. It's vigilance in those things. It's not to say we're going to take this entire religion and say you can't come here. It's no more justified than looking at Christians who bomb abortion clinics and saying, okay, we're not going to let Christians in here.
Right. Can
It's
you?
wrong.
All right. So, does this also apply to non-religious ideologies, like saying you can't come here if you're a communist or an anarchist or a Nazi, something along those lines?
That's an interesting question. It's not one I've ever given a lot of thought to. The First Amendment doesn't it addresses religion. It doesn't address political ideology. Could we say if you're an avowed Nazi, you can't come here? Probably. Of course, we got plenty of homegrown Nazis now. We don't need to import them. They're marching through the streets of Charlottesville. They're voting for Donald Trump. But could we kick out the Nazis that are here? I don't know. Whether that would be constitutionally allowed or not. I mean, I doubt it. I mean, that's viewpoint discrimination essentially. That's yeah. I doubt the courts would allow that. It's never actually come up that I know of.
All right, and I'll move on to the Ninth Amendment, which I know I skipped a lot, but this one really interests me because of
Me too.
Right, because of how loosely it can be interpreted. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage other restrained by the people. Now, this is a pretty interesting one because it was used, I believe, in Roe v. Wade to say that there's a right to privacy, and because there's a right to privacy, there's a right between the doctor and the patient, such that the state should not ban the procedure of abortion.
Right. Although the right to privacy predated that, it was just applied there. There's a really interesting history to the Ninth Amendment, and it goes back to that. Remember, I said talk about Madison bringing that list of 12 amendments.
Right.
So, the argument at the time over the Bill of Rights was this: some states' ratification convention said we demand a Bill of Rights so that we have a specific law to point to that keeps the government from violating our human rights. Opponents of that said that's a dangerous thing to do because we can't possibly list all of the rights that a person has. And if we put a Bill of Rights on there that lists these 35 rights, future government officials will look at that and say, well, if it's not on that list, we can violate it. So both sides agreed that they wanted to keep the government from violating our rights. They had a big disagreement on how to go about that, whether a Bill of Rights was necessary or whether they would actually make it less likely that those rights would be protected in the future. They made this political compromise because they just simply couldn't get the Constitution ratified if they didn't agree to put the Bill of Rights on. So James Madison, in his opening speech, where he presented this list of 12 amendments, said, I agree that there's great danger in putting together a list like this because future governments may decide that if it's not on the list, they're free to do whatever they want. But I think we can protect against that. And so one of these amendments, what eventually became the Ninth Amendment, addresses this concept of unenumerated rights, and it explicitly tells future government leaders and future courts, just because we didn't list it here doesn't mean you don't have the right to do it. Mm-hmm. And doesn't mean the government can do whatever they want. Now, that concept of unenumerated rights was applied long before we get anywhere near abortion or anything like that. You can go back to a case, 1922, Pierce versus Society of Sisters. And this was a case that established the right of people to send their children to Catholic schools. Mm-hmm. Constitution doesn't say you have that right. Nowhere does it address that whatsoever. Now, the argument from some quarters was, well, if the Constitution doesn't say we can't do it, we can do it. And the Catholics that were plaintiffs in that case said, no, Ninth Amendment. This is an unenumerated right. We should have the right to decide where we send our kids to school. And if we want to send our kids to a religious school, government shouldn't force us not to. The Supreme Court agreed. The right to send your kids to religious schools was established in that case. Case after case after case after case, over the last 125 years or so, you see unenumerated rights being protected by the court. What led to Roe v. Wade was a case initially called Griswold versus Connecticut, 1964 case involving birth control. This is where that right to privacy came from. And it was a case where in Rhode Island, where they had a state law saying that even married couples could not purchase birth control. And that was challenged in court. It went to the Supreme Court. In 1964, the Supreme Court struck down that law, saying that a married couple has a right to privacy in the decisions that they make as a couple that don't affect other people. And this law violates that right to privacy. And there was a very famous phrase in that ruling that conservatives like to mock, but they're being really disingenuous when they do. And it's where this term penumbra comes from. That the court sort of it is really kind of flowery language, but what the court ruling said was something like, and I can look it up, but I get the exact wording, but that there are certain parts of the Constitution that when you sort of put them together, you get emanations and penumbras that establish this basic right to privacy. And conservatives have forever mocked that language, but they will very quickly resort to penumbra reasoning themselves when it comes to a case like the Society of Sisters case.
The what?
Like the one in 1922 with the Society of Sisters, the right to send your kids to Catholic school.
Oh, I see.
They're all for that when it comes to when they like the outcome, Unenumerated rights are great. But what do you hear constantly? Whenever the courts protect a right that wasn't previously protected, conservatives say, well, where's that in the Constitution? Well, James Madison told us very clearly in 1790, that's the one question you cannot ask. That's the one question that is completely out of bounds. The fact that it's not listed here has nothing to do with whether it should be protected or not. But it was the right to privacy in 1964 that then eventually led to Roe v. Wade in 1973. They used that same argument to say, here is an intimate decision for a personal, private matter that doesn't affect other people. The government should stay out of it, essentially, as long as it's within the first 2 trimesters and blah, blah, blah. So the Ninth Amendment has been very important. Again, sometimes they get it right and sometimes they get it wrong. We will all agree on that probably. We won't all agree on which times it were right and which times it was wrong. But the concept that the courts can protect rights that were not specifically enumerated is absolutely crystal clear in the Constitution. And the one position you cannot take is that if it's not listed, the government can do whatever they want, because that was the one thing they made very explicit they were not saying, going back to originalism, So sometimes it'll lead to results that some of us don't like, and sometimes it'll lead to results that we do like. But the concept of protecting unenumerated rights should be unassailable.
Mm-hmm. And while we're on the topic of the Ninth Amendment, I'm not sure if you've ever heard this argument put forward, but imagine this hypothetical that you amassed enough political power that the Second Amendment was revoked, no longer applied anymore, or that it's far more limiting than we thought it was originally. Some people, there are some gun rights activists who've actually said you could appeal just as well to the Ninth Amendment because there is precedence in English common law, like in the Magna Carta, where gun rights were also protected there as well. Could someone just as well appeal to the Ninth Amendment in order to protect gun rights too?
They probably could. I don't know that it would work, because if we were to actually change that amendment, if we were actually to repeal that amendment on the grounds that this was not a protected right anymore, we're gonna remove the basis for it as a protected right, then the Ninth Amendment probably doesn't apply anymore. The meaning of that amendment being gone pretty clearly contradicts that. So I doubt that would be successful, but it's an interesting kind of argument to make. By the way, I want to tie back something we talked about at the beginning of that.
Go right ahead.
We talked about Robert Bork and his really radical views on the Constitution. Well, in two of these situations, this applies really. One is that case Griswold versus Connecticut. He wrote a law review article in, I think, 1971 or 72 about that case, in which he made what I regard as just one of the most surreally ridiculous arguments I've ever heard. And the weird thing about Bork is that everyone agreed that while his views were radical and while he was kind of a jerk, because he was really unpersonable, everybody agreed that he was this brilliant legal scholar, like among our greatest legal minds. And I'm, at the time, in 1987, I'm reading all of this. All of his law review articles and court rulings that he'd written and things. And I'm reading this and just going, where did they get brilliant legal mind? Because some of this is so dumb, I can't believe it. On the Griswold versus Connecticut case, this is what he said. He said, every case like this involves two people, two sides both wanting gratification. One side wants the right to do something, and the other side wants the right to stop them from doing something. And there's no reason why the government should gratify one right and one desire and not the other. And I'm reading this and I'm thinking, wait a minute. Yes, there is. One side wants to control their own lives, and the other side wants to control someone else's life. That's a really clear distinction between why the government should gratify one set of desires and not the other. Brilliant legal mind, and you can't grasp that distinction. You know. The other thing is that on the Ninth Amendment, he was asked about this during his confirmation hearing, because he had once written, and he railed against unenumerated rights in Griswold versus Connecticut, in Roe v. Wade. He wrote that the Ninth Amendment, because it doesn't specifically list anything, was a mere ink blot on the Constitution. It's as if someone spills ink over the top of the text, and we can no longer discern its meaning. We can't even read the text. It's meaningless. He believed that we shouldn't apply the Ninth Amendment at all. Now, that's a really radical position. Way more radical than anybody. I mean, he made Clarence Thomas look like a liberal by comparison. You know, he just had some absolutely deranged views on these issues. And to this day, Republicans still and conservatives still claim that he was railroaded. It was unfair that they didn't. He was such a brilliant legal mind, and we should have put him on the court. I shudder to think what the Supreme Court would have looked like with him on there. We had just gotten Scalia on there, who was pretty darn conservative, and then Bork, so Bork was turned down, and then Judge Dennis Ginsburg was nominated for that same position. He withdrew because a story came out that he had smoked pot with his students at Harvard Law, which today you would blink. And then Justice Anthony Kennedy ended up getting that spot on the Supreme Court. Now, replace Kennedy with Bork, and imagine what the last 35 years of jurisprudence would have looked like. We would be a radically different country in many ways. We dodged a huge bullet by not getting Bork on the court. Certainly the question of gay rights would be 180 degrees different from what we have now.
And I'm pretty sure Roe v. Wade wouldn't have turned out the same way.
Well, this is post Roe v. Wade.
Oh, right, my bad.
But it would have been overturned. I mean, 1991, very famously, Justice Kennedy cast the vote to uphold Roe v. Wade. Bork would not have done that. And initially, and this is one of the most fascinating cases, this is Planned Parenthood versus Casey, 1991, they took a vote. So after the oral argument happens, they have a conference. And it's I believe Thursdays at the Supreme Court. They'll hold a conference of just the justices. They didn't even allow law clerks in there. It's just the 9 justices. And they hold a vote on which way they're going to vote on each of the cases that they just heard a oral argument on. And so, it's literally raise your hand, okay, we have a 5-4 split. And the Chief Justice assigns who's going to write the opinion, the majority opinion and the minority opinion. And they will discuss this because sometimes there will be fractured opinions. There might be 2 or 3 or 4 or 5 different opinions. But the Chief Justice assigns it. So Justice Kennedy initially voted to overturn Roe v. Wade in that case. It was a 5-4 decision. And Chief Justice at the time, which would that have been Berger or Rehnquist? I think that still would have been Berger, but I don't remember exactly when Berger got off the court and Rehnquist took his place. But anyway, Chief Justice assigned him to write the opinion overturning Roe v. Wade. And he started working on the opinion. And then Justice O'Connor and Justice Souter, who was brand new in the court at the time, started working on him and started lobbying him. And basically they proposed a compromise. And they said, why don't we do this? Why don't we uphold the basic finding of Roe v. Wade that you have a right to an abortion, but accept most of these restrictions that the state of Pennsylvania has put on there that make it less likely and more difficult for people to get. And they eventually talked him into taking that position. So he had to go to the Chief Justice and say, I've changed my mind. So now, instead of writing the majority opinion to overturn, he was writing the majority opinion to uphold Roe v. Wade. And the minority opinion, and the other 4 justices who were joining them were the opposite of the 4 justices that he was originally writing for. So we came that close to having Roe v. Wade overturned. And if Bork had been there instead of Kennedy, it certainly would have been. So we would be a very, very, very different country today if Robert Bork had gotten out of court instead of Anthony Kennedy. And Anthony Kennedy, like I said, at gay rights, he authored all of the major gay rights decisions that we've had since he got on the court.
This is kind of besides the point of the Supreme Court and the Constitution, but just as an aside, when it comes to abortion, do you think since Roe v. Wade, the country's actually been more pro-life as opposed to pro-choice? Because at the time, go ahead.
The surveys that I've seen on this essentially say this. They sort of agree with what Kennedy ended up with on that Planned Parenthood case, where they say, we think women should have the right to have an abortion. But we're okay with some restrictions on that. We're okay with saying you can't do it in the 3rd trimester, for example, unless the life of the mother is threatened. We're okay with things like spousal consent laws or parental consent requirements, things like they're okay with some restrictions on it, but they still want, a fairly strong majority still thinks that the basic holding of Roe v. Wade should remain in place. That's kind of where the country is. The country's pretty moderate, on that question. Public opinion is. And now we're getting into a whole different. I mean, this has been a raging issue, of course, since Roe v. Wade. And it's not going to slow down any. I mean, this is as controversial a political subject as there is. I don't debate it with people. I simply don't, because I've never had a debate on the issue that didn't end with people screaming at each other. It just seems to be one of those issues that is so polarizing that I just avoid debating it with people for that reason. I mean, you and I could probably hold us. We've held enough civil discussions on controversial issues over the past years and respect each other enough. But I suspect you and I could probably hold a pretty civilized discussion on it while disagreeing. But as a general rule, I avoid it. It just makes me uncomfortable.
Yeah, I guess when it comes to that issue, saying, "Hey, I don't have a uterus, so I'm not going to comment." I guess that's actually one of the times where you're lucky to have that get out of jail free card.
Yeah, and listen, that basically is my position. Is that this is not my choice to make. And look, I'll be perfectly honest, and this is not something I've ever said publicly before. I've been involved in one of these decisions. More than 20 years ago, a girlfriend at the time got pregnant. And she was very strongly pro-choice. And she, came home and told me she was pregnant. It was not planned. We were using birth control. It wasn't something we wanted at the time. And said, "What do you want to do?" And I said, "Look, I told you, we've talked about this before, that if this were to happen, I leave that choice entirely up to you." And I meant it. I really do believe this is your choice to make and not mine. And whatever choice you make, I will be okay with. If you want to have a baby, I will be the best dad I could possibly be. And if you don't, I'm never going to make you feel guilty over it. I'm not going to, I don't feel a pressing need to have children myself, but I'm not opposed to it. So I really am kind of wishy-washy on this, and I really am going to leave it up to you. And whatever you decide, I'm fine with, and I'll be there regardless. And ultimately, she chose to terminate, and I think it was the right choice for her to make. But others, I'm sure, will disagree. She and I still talk now and then. It's we don't agree on much, but we agree on that. She made the right choice at the time. So I've been involved with this, and I sort of I did try to put my beliefs on that, my position into action, and say this really isn't my choice to make. It's yours, and I'll be there regardless. I'll do the right thing regardless. And I feel perfectly comfortable having made that, taken that position.
All right. Moving. All right. So I think I probably come to the point where I want to just tie up loose ends on this podcast. If there are any sources you'd recommend for people who are interested in learning more about the Constitution, what are some paramount readings?
Oh boy.
Aside from the document itself.
Yeah, the document itself is obviously great. The Federalist Papers are obviously great, but the language of those tend to be so unusual. The Federalist Papers in particular, the way they wrote in 1787 was sometimes be a little difficult. I'll give you a couple of really great books on this. One is by a Yale law scholar named Akil Amar, one of our really most brilliant legal scholars. And I believe it's called America's Constitution, a Biography, or something similar to that. Akhil is his first name, and Amar is his last name. And if you go on Amazon, I'm sure you could find the book. He's written many, but that one is sort of the whole history and background and meaning of the Constitution, written in a layman's language. Very well done. And the other one is Jack Balkin's book, Living Originalism. And that one's a little more dense. I would recommend reading Amar's book first and then reading Balkin's book. But that gets into these questions of constitutional legitimacy, framework originalism, and the different types of language that is found in the Constitution, and how that can be applied in ways that sort of breaks down that dichotomy between right and left, and originalism and living constitutionalism in a way that makes sense. So those would be the two books I would really strongly recommend.
All right, cool. And with that, thank you for joining us, Ed, and I hope everyone learned something from this amazing exchange.
Well, thanks for having me. Always great to talk to you, Edward.